Okay, guys. Good morning. Kind of morning. Anyway, I just came from my work and I just wanted to make this video because I really wanted to make this video. So what the hell happening in the university here is like, to be honest, in Western Australia, the education has been fucked up. Is sorry for the language, but this is the reality. Amount of the crap we are getting into the university is useless. The professors, lecturers, they've just been hired out of random, my friend, your friend, and the ghost thesis writing and everything. Especially couple of nationalities here, they are getting all their friends and everything into the university without having any subject matter knowledge or anything. Just and to teach a simple stuff. And the problem is that if you don't have an industry knowledge, at least little bit, so where you are in this country or anything, if you don't have enough language, just like smaller, even the exposure of that legal system in Western Australia, how the court works and everything. And second thing is that the traditional universities are not working. The traditional education system is not working. Is over, it's the overhaul process. India just did after 30-40 years. They have changed their education system. Australia does not. In Australia, there is no education system. It's just a business. After mining, this is the education is the second business. Okay, and the worst part is that because the education is directly linked to the permanent residency and citizenship, so people actually don't even bother what quality of education they are giving, what quality of the graduates are coming out of the industry, and as a result, the Australian industry are so reluctant to hire a local university graduate from the Australia. The reason is why, because they know what's happening here. And second thing, they are very much aware of the fact that so suddenly recently, because the university is under too much pressures and this and that we have seen some graduates are getting the job into the industry, and that's only under that's because they are very cheaper. So they get 40,000 for $50,000 as a graduate, and they've been exploited or they've been used for all this smaller kind of useless stuff. That's not my business to talk, but I'm just saying that I'm making this video after a long time. This may go a little bit over the limit. I'm trying to constrain all my video within 6 minutes, but this may go to 10 to 15 minutes. I'm not sure. Let's go. So what we are talking today about IRAC system. So if you go to the first semester of your university in any law school, okay, so they primarily focus on IRAC system. Come on, if you have been a student for because of doing graduation means that you must have your 10+2 qualification or something like that, So the question is here is that they spend 6 months, not 1 unit, 4 units, 6 months just to concept to teach this IRAC. And I'm telling you, 1 month is enough to teach this format. Max 2 months. If the professor, lecturers, they understand that it's their job to teach. It's not a club in the university where you go and you party on and all kind of those bullshit. Okay? So IRAC system. The first thing is issue. Issue is also, you can say, what is the questions? What is the argument about? Okay? So simple thing is that issue has to be divided into few categories. One is we need to teach the student where it's a civil matter. The first thing, if it's civil matter, the whole situation is different. Okay, if it's a criminal matter, the whole situation is different. Okay, so first what we need to teach, whether it's a civil matter or it's a criminal matter. Okay, and that can easily be deductible. Like it can be easily deduced from the fact that civil will have only the financial penalty and fines and everything, and criminals will have financial penalty, jail term, and all those things. So how we teach a student, and it's very straightforward. But in most of the questions, most of the law school questions, it will be easy. Okay, if the word damage, that means they're looking for money. Okay, so this whole system, like to deduce, like, so we are to most of the cases the questions will be given to you. Okay, or X trespass this property, property of Y, and damage this. So do you think X will be able to claim the damage from the from Y? So these are the questions already phrased. So there's not much to do with the civil or criminal matter, but identifying civil and criminal matter will only help you to find the cases from your database. Okay, so that's a different thing. That's a good thing to teach, but in the next video we'll see how to easily find the stuff you need. You don't have to be just junk yourself, put all the junks and everything in your mind or in your, because you have to just need very clear thing. Okay, don't make like too complicated. Just make it simple, straightforward. Okay, keep it simple. Okay, keep it simple, straightforward. Because what you do, so once you create, most of the time your issue will be given to you, then the rule. Okay, this is where I want to talk to you, the rule. Okay, so the university should be teaching and drafting a format, okay, where the student learn the lesson how to identify the rule, how to put the rule in the rule sections. Okay, first thing is the rule. Okay, so whenever you're writing a rule, so this should be the principle. Okay, principle / rule, okay, / judgment. Okay, and then second one should be is like the case. Okay, if it's coming from the case, okay, High Court Australia, Supreme Court of Australia, Supreme Court of Western Australia, whatever. Okay, and like this. Okay, and then finding of the case. Okay, finding of the case. So in case of torts and all those stuff, you will be there also will. So this what we need to start teaching student. In all the answers you do, at least mention 2 principle. Okay, minimum for each issue. Okay, or each concept. Like each question will have a different issue. Like one will maybe have trespassing, damages and all those things, but for each sub issue. Okay, so like for trespassing, 2 principle or 2 case. Okay, so principle, rule, judgment should be one thing. So you have to define the principle, anything, promises to follow, whatever, contract law, from the principle of the rule. Okay, sections, or you can also say the sections of the code. Okay, sections, the law sections. Okay, when I say sections, means law sections defined into the the criminal law code, or all those sections, subsections and all those things. Okay, IPP report sections and all those things are defined. Okay, so you define the principle, mention the name of the case it has been used. Okay, and what was the finding of the judge. 1. Okay, so this is what we have to drop them. 1 and 2 for sub issue. Okay, same thing, same principle. 3. So we should be giving the student, the teacher should be forcing the student how to mention the major main stuff. Okay, so this is where the judges or everything, law student or the law examiners, whatever, will look into. Okay, if there's a principle. Okay, if there's a case. Okay, what was the finding in this case. Okay, this principle, this case, this is a finding. So 3 things must be there. First thing, okay, second thing, and third thing. Okay, these 3 things must be there. Okay, so one sub issue, then another sub issue, another issue, and go like this. Okay, not more than 2. Okay, if you are practicing law, then you can put as much as you may, but that's not we are teaching. We are just teaching the format. Okay, what we are teaching here is the format only. Okay, because to be honest, not all the graduates will go to the laws to practice the law. Like they have all the different fields. Okay, but what we need to give them the tools. Okay, like when you go to the kindergarten, you learn A, B, C, D, E, F. When you go to the lower KG, you learn. When you go to the class 5, you learn the basic part of the human beings in biology or science, the physical science. As you process, as you progress, and you get the the Newton's law of motion, Newton's law of web optics. You go and increase your concept there as long as you progress when you go to the graduation and all the stuff. Similarly, for the law schools, it's just to make their foundation strong, so that they don't struggle. If somebody asks them out of the blue, okay, this is the matter, can you just draft a letter? So they should know in their mind that, okay, what is the principle here, what is the rule here, what is the judge, or what is the sections here, okay, and then, okay, which court has held that, and what is the finding. So these are the things they need to mention, okay, for each issue. Okay, when your rule is done, then what left is application. Same here. Application, when you're writing, so you take this one from your law. Okay, what was the first principle mentioned? Okay, and the second is finding of court. Principle, second finding of the code, and third thing where it comes here the third part is reference to questions. Reference to question or the case you are working on. Case or present case you are working on. Okay, so this is what important. So you mentioned the principle, like promissory estoppel principle, as used as observed in the case, as observed in this case. Finding is this. Based on that, my case is that, and this belongs to the, because of these facts, the case belongs to this, and the case belongs to the promissory estoppel or judiciary, whatever it is, whatever the section, subsection 21C should apply here. Okay, so this is what finding. So this how the teacher should put, not into go and do yourself unless you gave them the principle, gave them the format, gave them this. You have to sit down and make them. What you have to do here is to put first semester or in the law school, you have to make sure the student doesn't go out of this boundary. So what you have to make sure the student should aware of what the boundary is. Okay, the boundary is here, and in the boundary, okay, and then you start, okay, this is what, and this is what, and this is what. Okay, A, B, C, D. So they should know what that for A, B, C, D here. Okay, when I say A, B, C, D means issue, rule, application, and conclusion, IRAC. Okay, so we need to teach them what is the boundary is. Okay, what is the issue, rule, A, application, and conclusion. What is the ABCD of IRAC is. So once that, so this is how, this is what we should be teaching in the application. Okay, how to do it, and that's the clear format I will tell you. And once your rule and application section is, issue, rule, and application section is done, and the conclusion is similar. Okay, conclusion is very easy. Okay, conclusion is based on facts, small heading, based on facts. For example, see, based on recently any facts. So tell based on the facts of any like sections, based on this section, that sections. Okay, this was very good example I wanted to mention here is okay, based on this, I'll tell you, I'll come back to you. Okay, based on this fact and everything, because I'm doing this myself, there's no presentation, no slides in front of me. This is all purely my knowledge. That's why I'm saying. So I'll tell you, okay, based on the concept of, like, okay, like risk, liability, okay, frolic of own, okay, vicarious liability, frolic of own, prohibition, okay, prohibition in place and this and that. My client is guilty or not guilty, whatever, the plaintiff is guilty or not, or the complainant is defendant or whatever is guilty or not, that's your findings should be. But what I wanted to and how this will be observed in an easy way is like this, okay. So we draft a format, okay. Format is issue, okay. So define, so should be there what if, okay, bill xyz succeed, like this, okay. Just telling you. When the rule come, in the rule section they should define a box, okay, this, okay. Okay, this box, it should be principal, sections, okay, law, okay, or finding, okay. So this is, and then you come back to this side, okay. This side, High Court, Supreme Court, okay, case name, reference, footnote, okay. So in the second part they should have which court it is, what was the case, reference and footnote. And third things, finding or held by justice or court, okay. So at least if there's a more principle we can put more, if there's a more section we can put more section, okay. So they should understand this concept, okay. This concept is very important, okay. Principle 2 or section 2 or the law 2 and finding 2, okay. So and then again a case, okay, then again the finding what was held, again principle 3, law 3, section 3, that, okay. And the application section, when we go to application, same thing, what it should be, application is there, okay, principle, okay, case name, okay, and association with your case, or application to your case, So what I'm trying to teach you, or trying to say here, this should be the format to apply the application. Just not apply this, no. As long as the student, the founding student, the first semester student or any student knows how if they know this, or okay, so when they put this structure around their assignment or their case or their practice, they just need to add, okay, you add, and this is correct, you add this equal to your result is good, okay, equal to your result achieved, so that's what you want your result to be achieved. And then the conclusion is straightforward. In the conclusion, when you do, okay, so P1, P2, P3, okay, based on the P1, P2, P3, my client is guilty, not guilty, that's it. So whatever the principle you use, you mention the principle, because of this principle is applicable to my case, and this is the finding. Smart, simple, straightforward way, okay. And this is what the university should be teaching lecture studying. We don't want to, nobody, university have no capability, especially when none of them lecturer has gone to the court and see the how court perform and everything. It's totally useless to boast themselves or to show them I know everything. They know nothing. Okay, that's why it's important, especially in this kind of subject or kind of subject matter law where the dispute negotiations are involved with. The person has to be from the industry. Okay, science, those all are theoretical based subject. That's a different. Law is practical based subject. Okay, so that's when the person has to go to the court. At least you have spent some more knowledge to learn. My addition is to that, in the same process they should be giving them how to write and what are the forms available in the court at the moment, how they are doing, what they are using. But apparently that's a different things they are teaching in the College of Law, which is another waste of money. Okay, so this format I haven't seen anybody teaching in the law school. Okay, they are putting all the garbage and this and that. Those garbage are not necessary. Okay, in the current age, we are in the information age. There's a way too many information available online platform, and information as people are dumping information on a larger scale. What they used to spend, what used to dump on 10 years ago. So very important for the teachers, for the lecturers, for all those people who are in the education industry to understand and filter them and give the right information, the right tricks, right tactics, right model to the people, to the student who can be industry prepared. Okay, most of the law student, if you see the mature age student, they are not there for knowledge. Okay, they are not there for to basically learn, because all the mature age students are already know the industry, have worked in the industry or aware of the industry. Okay, they are here to that piece of paper. Okay, required by the Law Society of Western Australia to be admitted as a lawyer, or required by Migration Agent Registration Authority to become a migration lawyer, or required by convincing like to become a settlement agent and all those things. So what I'm gonna again do is rephrase again what I just want to wrap up because the video is going way too long. So issue, most of the time issue is given to you. Okay, issue is always given to you. Rule, okay, principle 1, principle 2, principle, never principle. Okay, these are the principles that exist based on the sub. That's why the tutorial should be focused on only the few principles that being commonly used in Australia or which is commonly in practice. Okay, so a principle and the case associated to it and the finding. Then again the principle to case associated with finding. So there will be 2 box. Okay, and this should be given like this, and then the application, principle, case name and association with your case. Principle, case name and your association with your case or your questions, and then conclusion based on the principle 1, principle 2, principle 3, principle 4. I think my client is not guilty or my client is guilty, and that's it. And this is the simple, straightforward. Why, I don't know. They're making the life so hard for people. They're not learning. They're just wasting the time, wasting of money. I'm into this because I need that piece of paper. Thank you.